All rise.
You may be seated. The next case for consideration this morning is Domains News Media versus Hilton Head Island Bluffton Chamber of Commerce. Council prepared to go for it?
May it please the court, Tina Kandari on behalf of the Hilton Head Island Bluffton Chamber of Commerce. The issue in this case is whether the chamber is a public body subject to the South Carolina Freedom of Information Act because it receives public funds to provide advertising and tourism-related goods and services to the local government entities in which its members conduct business. The question before the court this morning has been answered in both the Weston case and the DeSabato case. In the Weston case, this court expressly held that private entities that receive public funds in exchange for supplying goods and services on an arm's-length basis are not subject to Foia. That is exactly what we have in this case this morning. The same thing was recognized in the DeSabato case 22 years later, in which this court stated that Foia does not apply to a private entity that receives public funds for a specific purpose. Again, the chamber in this case is doing exactly what the courts recognized in Weston and DeSabato. It is providing goods and services pursuant to a statute, which the General Assembly enacted, saying how these funds would be spent, and is doing so on an arm's-length basis. For this reason alone, this court should reverse the trial court's decision. If you take a look at Title VI, 645 through 35, General Assembly states that 30% of the balance of these accommodations tax dollars are to be used only for advertising and promotion of tourism. The process outlined in that statute is extensive, requires a budget to be submitted, it requires an accounting to be submitted, and so the General Assembly has put in place all of the checks that would allow a member of the public to find out how this money is being spent, how much money is being spent.
Well, they say that those checks on the ATAX statutory framework is not as intense or doesn't provide as much in terms of the accountability and transparency that exist on the Foia side of the statute. What say you to that?
There is nothing in Foia that requires the level of specificity that they are seeking in this case. There's nothing in Foia that requires a local government body to maintain receipts for every purchase, for every paperclip, for every ream of paper. That's the level of detail they are seeking in this case. And I would encourage the court to look at the statute. The General Assembly obviously thought that there were enough checks in place for the spending of these funds through that budget and that accounting process. And if they want some more specificity, there are plenty of places they can go to find it. The first being the town council itself, which approved the budget, which oversaw the accounting. And so if they want more information, they can go to their local town council and get that information. It is not a wise decision to convert these private membership-based organizations like the Chamber and so many other organizations in our state that provide valuable services to the public, to convert them into public bodies, opening their doors, transforming the way they do business, eroding those relationships.
Let's break your argument down a little bit and looking specifically, and first of all, tell me if I'm correct in the starting point of my question, but if I'm looking at the budget that the Hilton Head Bluffton Chamber of Commerce gave to the governmental entities that provided the accommodations tax dollars for the fiscal year 2013 and 14, I would look on page 546 of the record and beyond. And there's a line item. I mean, I could pick any one of them for purposes of this question, but the one that strikes me as interesting is the line item for SEM marketing, $200,000. So obviously this document is available to any member of the public from the governmental entity. They don't have to come to the Chamber of Commerce to get that document. But if the member of the public wanted to break down what that $200,000 represents, either in anticipated spending, because this is the budget, these are funds that have not yet been spent, or if it were to pick it up on the back end in the year-end report, how could that member of the public find out additional information about what it means, what this $200,000 represents?
They could ask the town council to request that information from the chamber, and the chamber would have to provide it.
Through the Freedom of Information Act?
No, through their relationship, through their status as the DMO. This is what's happening.
No. If a member of the public wanted to get this information, your argument to Justice Kittredge's question, as I understood it, was that the Accommodations Tax Act requires the governmental entities to maintain sufficient detail about information that would otherwise be available through the Freedom of Information Act, such that that information is available without having to get it from the Chamber of Commerce.
I don't think that the Act requires the government entity to maintain the level of detail as requested by the respondent. I think what the Act requires...
Well, my question doesn't depend on the level of detail asked by the respondent. So I don't want to get hung up on paper clips. I want to know how a member of the public can figure out what this $200,000 for SEM marketing represents.
And my answer is they can ask the town council. They can go to there are many levels of oversight. One is the council itself. So they could go to the council and say, I don't understand what this number is. We want more information.
So does the council know? I mean, this document that I'm quoting is your document. It's the document you provide to the town council, and you propose in your budget that the chamber will spend $200,000 on SEM marketing. Mm-hmm. I mean, I looked through the record. I couldn't find it, but it's a huge record, and I didn't really know what I was looking for. Is there anything in the record that would show me what that $200,000 represents?
No.
So what type of document or what type of information would someone ask for when they go to the town council to figure out what the $200,000 is?
I think they could take this budget and say, this is a budget you approved, and I don't understand it. I want to know more about what's going on here, and I urge you to get that information.
But that is so what you're telling me, I think, is that the town doesn't have the information as a matter of course, in its relationship. In the town's relationship with the Chamber of Commerce that we're talking about here, as a matter of course, the town doesn't know what the $200,000 represents for SEM marketing.
Well, it may. I don't know. All I know is that this is a marketing plan that is submitted to the town. The town does. It has an oversight committee, an advisory committee.
So isn't that kind of important to the question of whether the Accommodations Tax Act independently makes available to the governmental entities and through that the public the level of detail that the legislature intended? Isn't it important that in fact that's not required because for example, the SEM marketing dollars may not ever be known by the town?
I think that the Act provides the level of detail that satisfies the General Assembly that this money is being spent appropriately. And I think that's the only thing that the public is entitled to.
So there is no requirement to satisfy the Freedom of Information Act?
Well, of course, if it's a public, the town council is subject to the Freedom of Information Act, so the town council would have to answer in that regard, but the chamber's not.
If the town, instead of the chamber, had spent $200,000 on SEM marketing, which I know because I Googled it, stands for Search Engine Marketing. It's not the name of a company. But if the town had spent the $200,000 on this marketing, then a member of the public, through the Freedom of Information Act, would have been able to find out exactly to whom the money was spent, whether it was spent pursuant to competitive bids or not, whether the highest bid were selected, what were the specifics in the proposals that were given by the companies that were going to perform the marketing services, and so forth, and on and on and on. Am I correct?
You are correct, and I would say that the town is spending this money. These dollars are coming from the town for these specific purposes. The chamber is simply carrying out what the town wants to spend the money on. I'm sorry.
Well, then I'll leave it at this. But unless, and this is a question, unless somehow the town takes the initiative to learn from the Chamber of Commerce what the $200,000 represents, then in our scenario, a member of the public would never be able to gain access to the individual vendors, whether they submitted bids, what were the bids, what was the highest bid, and on and on and on and on. Is that correct?
I think the most important part of your statement is the beginning part that said, unless the town pursues it. And the point is that the town can pursue it. I mean, this is the town's
So to be
money.
clear, the answer is yes, I'm correct, but it's very important in your argument that the town can follow up and get this information if it wants.
Absolutely.
Okay.
And that the chamber is simply responding to the ability of the town to pick them or recognize them as an appropriate DOM under the accommodations tax statute.
Correct.
Thank you. Your time has expired.
Thank you.
Thank you, Mr. Chief Justice. I'm Taylor Smith, here for the respondent domains newmedia.com.
Is domain still active?
My understanding, Your Honor, is that that was initially a sole proprietorship and that its ongoing concern at this point is this litigation. I have no understanding other than that at this time.
According to the Secretary of State's website, your client was dissolved as a corporation on August 30th of this year.
That's correct, Your Honor. That was the understanding of the Secretary of State, and that is in terms of the filings with the Secretary of State and the executive branch of this government. However, it initially was a sole proprietorship. It did convert into an LLC, and at this point is, again, a sole proprietorship that is ongoing concern is this litigation. Thank you, Your Honor. Undisputed in this case, as questioning, as I understand, has already come from the bench, is the status of this organization as a designated marketing organization and its requirements under Title VI and Title 12 of the South Carolina Code of Laws to get what is commonly referred to as beds and heads tax, accommodations tax monies funneled back to it. Under Title VI and Title 12, they have a statutory duty to spend those public monies. They have fulfilled that duty from what I have seen in the record in this case. It is in doing so that this entity is also one that meets the definition for what a public body is under the South Carolina Freedom of Information Act. 3420A provides that a public body means any organization, corporation, or agency supported in whole or in part by public funds or expending public funds. Now, this court had the opportunity in 1990 to address this issue involving the Carolina, the Carolina Research and Development Foundation. And it first had to deal with the argument that was initially proposed in this case at the trial court. If we're a private 501 organization, how can we be a public body? The court dispelled that, saying that the common law concept of public versus private is inconsistent with Foia's definition of a public body and can't be superimposed on Foia. The court went further and said that when you have a block of public funds that's diverted en masse from a traditional public body, such as a state or a county, or in this case, perhaps a town, and it goes to a related organization, or when that organization then undertakes the management of the spending of those public funds, it is a public body for the purposes of Foia. And the reason the court said that that should be true and that the statute should be strictly construed towards its intended purpose of giving citizens the right to learn the activities of public officials at minimum cost or delay.
If you're correct, what do you envision to be the reach of Foia into the chamber? How much of Foia is going to be imposed on the chamber and other private institutions that receive $1 of public funds?
I think this court had that correct in Weston when they noted that there will be situations where you have that exchange of money for goods and services on behalf of a private organization.
So they're not a public body.
Right.
All right. But your argument is the chamber, because they receive some funds for the accommodation tax pursuant to statute, they're a public body. Let's just say we accept that premise. What does that mean? Does that mean that the chamber must start giving notice of its meetings, the agenda in advance, and all the rules that pertain to special meetings, executive session, and on and on?
Your Honor, it would. Under Foia, we do not have a way to distinguish between the duties an agency has in its open meeting requirements versus the requirements it has under its open record provisions.
So the legislature has created a very specific, targeted statute, as well as Proviso 39.2 that deals with these dollars. And they comply with the statute. And the statute has certain reporting requirements. And then there's Turk oversight and things of that the statute. But we are to assume that that the legislature did not give enough accountability. The legislature did not go far enough. So we're to borrow from the FOIA requirements and overlay it on this new determined public body, now the chamber, correct?
That's correct, Your Honor, and we can assume that from the timeline the legislature enacted this legislation. We have the public body definition for FOIA that was enacted in 1988, and we have 6.3.10.3, which provided for the management and the direct expenditure of these funds that came out in 1990. The legislature, certainly at that time, with an understanding of laws in the books concerning what was a public body, could have said that
why wouldn't that be just the opposite? They knew the general law of FOIA, and they enacted a specific law dealing with these discrete funds and provided a mechanism for accountability and transparency. Why wouldn't that specific legislation trump the general FOIA requirement?
This entity does not have to organize in the way it has. Traditionally, chambers of commerce are private, purely funded through members in your organization. However, in this instance, they have chosen to take what traditionally is the promotion of tourism done by what we usually consider convention and visitors bureaus and put it under one organization. The trial court, in this case, in its order, had to wrestle with that idea. Is there a way for us to separate?
This is not something the chamber created out of thin air. The chamber is suggested as a DOM by the legislature. Does that make a difference?
This chamber had to become a DMO for those entities. It sought that status. And in doing so, it came with the responsibilities under ATAX, and by fulfilling those responsibilities under ATAX, would also be held to fulfill the definition of what is a public body under FOIA. Had the legislature intended to carve it out, I think they would have in 1990. I don't have much time
Let me ask you a question that's following up on what Justice Kittredge asked. Your answer to his question seems to me to create conflict in the law. Because not only under your answer would the chamber be subject to the Freedom of Information Act in such a way that it must give public notice of its meetings, but the chambers around the state typically perform a political function for its members. Chambers act in formal and informal ways to advance the political motives of its members, and the members pay money to the chamber in order to enable themselves to do that collectively, right?
Right. That's my understanding, Your Honor.
If you answer Justice Kittredge's question such that the fact that they're a public body means the whole, I guess it means the whole Freedom of Information Act applies, then the chamber's political activities become public.
That is correct. If they receive public funds...
I get the structure of your argument of how you get there, but really, how in the world could the legislature have intended that?
The legislature, from my understanding, Your Honor, probably did not conceive of this hybrid format that this chamber and other chambers in the state have created, to say that we have this one side which does take public funds and promotes tourism locally. Yet we have this other side, which is the traditional chamber.
Chambers of commerce are not new, and their political functions are not new. I mean, I'm not a historian on Chamber of Commerce functions, but when these acts were enacted, surely the members of the legislature, as they go through their daily activities, being lobbied by chamber lobbyists, they knew that the chamber is involved in political activity.
And they knew as of 1988 that if they were to expend public funds, they would have potential liability under FOIA.
Well, I guess
if they
that's the
refused a
question
FOIA
here.
request.
Maybe it didn't occur to the legislature that by, as Justice Kittredge points out, nominating chambers of commerce as the first option for the entity to take and spend these funds, maybe it didn't occur to them that by doing so, once you pull in the Freedom of Information Act, they would, by virtue of that, create a situation where private political activity becomes public as an operation of state law, which has all sorts of legal problems that arise from it. Maybe they didn't realize that.
It's possible, Your Honor. I can't answer for the legislature. I do need to point out that the purpose of FOIA provides that the provisions of this chapter must be construed to make it so necessary so people can understand the activities of how public monies are spent and how public officials
that's the rub I have with this. You do not want to limit FOIA's application to the expenditure of public funds. You want to go and just put tentacles in every little aspect of the chamber.
Your Honor, by the way they have organized, that would be the effect in this case. I honestly believe...
No, you said there was they created a separate entity within the chamber to handle this.
Right, but it is one jural personality, Your Honor. It is but a division of the Hilton Head Island Bluffton Chamber of Commerce, and as such would be subject to FOIA by spending these public funds. If we were to go further and keep this as the status quo...
Well, let me ask you this. If it were limited to the expenditure of the funds and the mechanism that the chamber uses to do so, what would be the problem?
Your Honor, if there was a way to clearly account for how the public funds were spent, and there was a way to isolate that within the accounts, within the activities, within the operation of this chamber, then that would be something that would fulfill the purpose of FOIA. However, in this case, the trial judge wrestled with that idea and said that he, as a matter of law, could not separate this organization out as to those activities which are traditionally member-funded and private versus those that are publicly funded. If we were to keep it as it is now, we would probably come up against what this court anticipated 4 years ago in Disabido when it said that if public bodies were not subject to FOIA, government bodies could subvert the FOIA by funneling state funds to nonprofit corporations so those corporations could act outside the public's view as proxies of the state. As Justice Few has pointed out, you can pick up this record. You can look at budgets. You can even look at the audit reports. You will not find with specificity, as this court required in Weston, how public monies were spent. I see I'm out of time, Your Honor.
And it would be nice, perhaps, if there were some way legally to say that the private political activities of the chamber can be not subject to FOIA and the use of public funds can be. But in reality, there's nothing in the statute that we could point to accomplish that distinction, is there?
That's correct, Your Honor.
Other than our interpretation of the statute.
That's correct, Your Honor.
Okay.
Thank you.
Very briefly in reply, I submit to the court that there is nothing in the statute that would provide for FOIA to apply, but there doesn't need to be. I mean, this statute is so rigorous in the budgeting and reporting requirements and all the oversight that goes with these funds. It is.
You've just explained, Ms. Kandar, that it is not. When you answered Justice Few's question, failed to answer his question because you didn't know. So how is it that it could be so clear that there is oversight in so many different layers? I understand there are other committees, if you will, who are required to take a look at this, but if a common citizen tried to find this information out, you've just explained to us, that's going to be very difficult to do.
Well, it's not going to be difficult, and if I suggested that, I misspoke. The budgeting process is public, and so concerned citizens can attend those meetings. They can attend the advisory committee meetings. They can attend the town council meetings. They can also impress.
Does that somehow get rid of the requirement to be open and apparent with freedom of information?
I'm sorry, I don't understand your question.
Simple. Simply because I can attend my city council meeting, does that mean the city council is not subject to FOIA?
No, they are subject to FOIA, and that's exactly, that's the remedy here. That's where you get this more specific information that they're seeking. I mean, the bottom line is there's just no reason for FOIA to apply to these funds.
Well, I have, you can tell from my questions about the Chamber's political activities that I find it highly offensive that the state might stick its tentacles into the political activities of private entities. But if the Chamber had desired to do so, or any chamber, or any organization that meets this definition of under 64.6.410 subsection 3 as having an existing ongoing tourist promotion program, any organization in the state could, if they chose to, separate that out as a separate entity, separate out their existing ongoing tourist promotion program as a separate entity, such so that they could comply with FOIA with regard to these public funds and not be subject to FOIA with regard to their own private activities.
They could do that, but they don't have to.
It'd be very easy, wouldn't it?
I don't know that it would be easy. I mean, I think the way that the Chamber is, the General Assembly obviously thought that chambers of commerce were perfect for doing this sort of work. I mean, they have their finger on the pulse of what's going on in their communities, the business community. They are the first listed example of a DMO. Then you've got your visitor and convention bureaus. Then you have other organizations. And if the town's not satisfied with any of those in its regions, they can create their own. So, you know, there's no reason to apply FOIA to the Chamber in this case. This statutory scheme provides for the transparency of these funds. And I would end with saying I think it would be terrible precedent for this court to affirm the trial court's decision, not only for the Chamber. We've already mentioned how that would transform, Justice Kittredge, the way it would transform the business of the Chamber, opening its doors to anyone and everyone, the meetings, the minutes, et cetera. And for other entities like the Chamber. You know, there are plenty of nonprofits and private entities that depend on public dollars to do important work in our communities and our state. And I would hate to see those relationships eroded. I don't think that would be good precedent. So we ask the court to reverse. Thank you.
Thank you very much.